Right, and we will move on to hypo number 5. So in number 5, our hypo is A sues X to recover the contract price for goods sold. So with this contract, A and X entered into a written contract for A to sell X 1,000 metric tons of lead fume. The contract price was dependent on the exact weight and metallic content of the lead fume delivered by A. To prove the weight and content, A testifies that she employed B, a highly respected assayer, to assay a sample of the lead fume, and that she later went by B's office and received from a secretary there a report on the letterhead of B saying that it had B's signature, and that she, however, was not familiar with B's signature herself. So the report she received has B's signature on it, but she's not able to authenticate it as an accurate signature. A then offers into evidence this report with B's signature on it, which sets forth the weight and the content of the sample of lead fume allegedly assayed by B. And so X makes a hearsay objection. What is our result here? So under both federal and California law, this objection will likely be sustained. So again, we are looking at our 5 factors with our business record exception. One of those factors is that there is a qualified witness or a custodian of the record who gives testimony to lay the foundation for the business record. They have to say how it was prepared and give us the facts about how it's within the normal course of business. In this case, in this hypo, we are lacking that factor. And so it's easy to kind of gloss over some of the factors, like that there needs to be a qualified witness or custodian who actually testifies at trial for this hearsay exception to apply. And so even though, the answer might be if a qualified witness or custodian testifies, then yes, this, exception could apply, or whatever your analysis may be. And that might be what happens on your hypos or your essays. You want to note the 5 factors in your rule statement, and then in your analysis, if your hypo or your fact pattern does not talk about a custodian or a qualified witness testifying to lay that foundation for the record, you need to flag that in your analysis. And it's okay if your analysis is if the party introducing the record has a qualified witness testify to lay that foundation, then, it's met all the other factors, and yes, it can be admissible. But if they don't, then this would be inadmissible. Like we've talked about a few times, you don't want to cut your essay short if, for deciding that something should not be admissible. And so it's sometimes good to do the alternative of saying, if they have this witness testify, then this would be an admissible piece, and then go on to that likely inner piece of hearsay within the written record. Because again, while we're dealing with business records, we're usually dealing with double hearsay. Our outer layer being the writing itself, our inner layer being potential hearsay statements written into the record. And so for the analysis, you want to be able to get to that inner statement and analyze that as well. Okay, number 6. Our hypo for number 6, we have A sues X for damages for personal injuries and car property damage arising out of a automobile accident. A testifies that he went to Dr. B at C hospital for treatment and had his car repaired at D garage. A offers evidence bills and invoices, which he testifies as having been received from Dr. B, hospital C, and D garage. Each bill is stamped with the words payments received. X makes a hearsay objection to the admissibility of these bills. How should the court rule? Again, both under federal and California law, this objection would likely be sustained. The bills and the invoices are hearsay, These are statements from the doctor, the hospital, the garage operators. They're being offered by A to prove the truth of the matter asserted. They're being offered to show that this is how much these bills cost, that it was a reasonable amount, and that he needed to pay them. And now A is saying that X should be responsible for that amount of money. The problem here is that these bills don't qualify for our business record exception. Again, we lack a qualified witness or a custodian of the record to lay that foundation for this business record exception. This will come up a lot. I think you assume that that person is testifying, but without a fact pattern that specifically says there's a qualified witness testifying to the production of these records, it does not qualify for a business record exception. You need that piece. So as you're going through your analysis, there are 5 factors, and you need to go through each one. And if you don't have any one of those 5 factors, you fail the analysis for a business record exception, and it's not going to come in. Like in our last question again, in your analysis, you can say, if they were to bring a qualified witness to testify, blah, 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 then you could continue on with your analysis. But that is a really important piece to note. Number 7. In number 7, we have a defendant who is charged with the robbery of V, a liquor store owner at his store. V testifies that after the robbery, he ran out of the store and saw D's license plate number as he drove off. V testifies that the license plate number on the car was 468 ABC. D's car does have this license plate number. D calls the police records custodian, who identifies a police report of the event and establishes the foundation at trial that it was made in the usual course of business and at or near the time of the robbery. A sentence in the report states that 30 minutes after the robbery, the police received a phone call from A neighbor of the victim, who reported that the license plate number on the robbed car was 416 ABC. D offers the police report into evidence. The response to the prosecutor's hearsay objection, D states that the report is being offered as non-hearsay to establish that the license plates were different, the numbers were different. But that even if it was hearsay, the report is admissible under the public record, official record, hearsay exception. Our question is, should the prosecutor's objection be sustained? So the first thing to note here is that we're dealing with a criminal case, and when we're dealing with a criminal case, we're thinking potential confrontation clause issues. The good thing here is that there is no confrontation clause problem because the defendant is actually the one offering the statement. So remember, the defendant has a right to confront his witnesses. When we're dealing with hearsay, we're dealing with someone who's actually not in court testifying, which can cause problems for our criminal defendant. But that's only a problem if it's being offered by the other side. Right here, it's not a witness against the defendant. The defendant is the one offering the report. So no confrontation clause issue here. So we'll start with federal law. So the police report is inadmissible hearsay. We'll go through the analysis, but that is our answer here. Our police report is inadmissible hearsay. So we'll start with the non-hearsay argument. So even though, the issue here is the differing license plate numbers. So this is arguably, if it's not being offered for its truth, it's being offered to impeach, to say, you say that the license plate you saw was my car's number, but here's a report from your neighbor that says it was a different license plate number. To have that statement be used for impeachment, you do actually have to offer it for its truth. You want us to believe that the neighbor is giving us the license plate of the car that committed the robbery. So even though it might be offered for a non-hearsay purpose like impeachment, it still is needing, you're still asking the jury to accept the statement for its truth. I think the difference here, which might confuse folks, is this is different than just a prior inconsistent statement, which is a hearsay exception. In this case, a prior inconsistent statement needs to come from the same person. So, for example, if the victim saw the license plate number and said it was one thing, and then later said it was a different number, we would be dealing with a prior inconsistent statement. In this case, though, we have a victim saying one number and a neighbor saying another. So their stories haven't changed. It's just two people giving a different account. Okay, so under federal law, again, police reports are inadmissible hearsay. So the first argument might be the public records argument. So this is 803.8. This doesn't apply because the declarant, the neighbor, again, it doesn't have a duty to report. They're not the public officer. The reason we have these public records exceptions are because we think government officials, public officials have some higher duty to, tell us the truth, whether we believe that or not. But within this record is the neighbor statement, which is really what we're getting at. And that neighbor is not a public official. They don't have that higher duty to report. And additionally, this rule explicitly does not let you use law enforcement records by either the plaintiff or the defendant because we're dealing with a criminal case. So that's a criminal police report. And then additionally, if we're looking at just the different parts of FRE 803.8, that first section there was 803.8b, if you want to just pull up the FRE and kind of look through it as we're talking. And then if you go down to 803.8c. So this section doesn't apply because the report isn't a finding. So the officer isn't making a finding of fact that the license plate number was 416. They were just recording information that the neighbor told them. And then we move to California law. So police report, still inadmissible hearsay. For this, the source of the information doesn't give us that trustworthiness piece that we need. So again, the informant, the neighbor, they're not the public employee. That neighbor does not have a duty to observe or report the facts correctly. And in California, we need that affirmative proof of trustworthiness. And in this case, we don't have it. It's not the officer who's making the statement. It's the neighbor. Let's see, what else did I want to highlight on this? So I think just the kind of bigger picture here is just because you have a public record or a business record that might on its face qualify under these hearsay exceptions, you do still need to think about what's within them. So the statements within them. The statement that we're looking at here specifically was from this neighbor. Maybe there were other pieces in the record that could have been admissible, that were made by the officer or the public official. But the one that we're concerned with in this hypo was by a neighbor, and so that's important. And so you want, when you're doing your analysis for these exceptions, you want to be really careful about who's making the statements within these records, because that does become important. Number 8. So in this hypo, we have Sam D. is charged with perjury because he allegedly gave false testimony in a civil trial. The prosecution contends that the false testimony in that civil action is that Sam D. identified himself by the name of John D., while his real name is Sam D., and that in qualifying to testify as an expert, he said he was a standing consultant in an engineering at the U.S. Bureau of Mines. The prosecution offers into evidence a writing stating that C, the signer, was the official custodian of records for the U.S. Bureau of Mines, and that C had made a diligent search of the records and failed to find any record that any person by either the name of Sam D. or John D. had been an engineering consultant. The writing has C's signature as custodian of the records for the U.S. Bureau of Mines and is stamped with a seal that is from the U.S. Bureau of Mines. D makes a hearsay objection to the writing, and our question is, what is the result? So there is a confrontation clause issue here before we get into the hearsay exceptions. So it might be that C's writing here is just for the purpose of providing evidence at trial, meaning it would be testimonial. Courts have found this in other kind of similar fact patterns, that these kind of reports or records are testimonial. So that is potentially an issue. Anytime we're dealing with a criminal case and a defendant and hearsay, we're thinking confrontation clause. So now we're considering moving on to the hearsay exception issues. So under federal law, we have hearsay exception 803.10. So this is the absence of an entry in a public record. So that is just a hearsay exception. The absence of a record is hearsay and does fall under this exception, and so that can come in. And the seal, the certificate, the seal that we have on this writing is enough to authenticate it. So instead of needing that custodian of the record or qualified witness to testify about it, some things are called self-authenticating. And things with official seals or certificates like this, these documents are self-authenticating. So that trustworthiness piece or authentication piece is established just by the fact that this has a seal on it. Okay, and then for our California law, we have a similar hearsay exception. Our code is CEC 1284. This is, again, the absence of a public record itself can be admissible under a hearsay exception. And the language of that, I'll just read it for you, is the evidence of a writing made by the public employee who is the official custodian of the records in the public office, reciting diligent search and failure to find a record, is admissible by the hearsay rule when offered to prove the absence of that record. So if you have the custodian of the record, they write something up and say they searched for something and they failed to find it, that writing, that record that they have now made, can be admissible at trial. And number 9, our last typo. In this typo, we have a defendant who is accused of committing murder in a home on Green Street. His defense is that he has an alibi. He claims he was 600 miles away at the time of the crime. The prosecution has a record of a traffic citation that was issued on the night of the murder to the defendant's car. And his car, they have as being parked on Green Street sidewalk near where the crime scene was. The citation contains the license plate number for the defendant's car and the time and the location of the parking ticket. It was issued by a police officer with general law enforcement duties who now has no present memory of the vehicle or its license plate number. The murder had not been discovered at the time this traffic citation was issued. The prosecution wants to use the record of the citation at trial. And our question is the record testimonial within the meaning of Crawford, which was our case that deals with the confrontation clause? And then, assuming it's not, what hearsay exceptions might we use? So our first question is this testimonial? Do we have a confrontation clause issue here? And so it was definitely a writing for law enforcement purposes. It was written by a police officer. But you could argue that it wasn't written in anticipation of litigation. They didn't know about the murder when they issued this traffic citation. So, it wasn't definitely not in connection with this murder. How could it be they didn't know it happened yet? So let's assume that a court finds it's not testimonial or we don't have a confrontation clause issue. There's 4 possible hearsay exceptions that we're going to go through. So the first one is the public records exception. Again, the big problem here is this is a law enforcement record, so we're dealing with potentially, our police report problem. So you could argue that this is just a routine record of objective facts, not adversarial, like when you're dealing with, some kind of criminal police report. This is just a traffic citation, which ultimately is kind of the reason behind why Congress is concerned about police records. This argument goes directly against the actual language of the FRE, but some courts don't care and have been open to this argument. So even though it's directly against what the FRE rules say, sometimes it's still worth bringing that argument. You want to look at the, legislative reasoning behind why these rules were made. And if Congress is really just concerned with our, criminal defendants being convicted based on criminal police reports, this isn't quite what's going on here. So you might be able to argue your way out of this exception, but it is directly against what the public records exception rule says. So we'll move on to a different one. What about the business record exception? So if the ticket doesn't qualify as a public records exception because it was a law enforcement record, it probably also wouldn't qualify as a business record, which is just kind of more general than a public record. But again, similar to the last one, you could argue that the facts of this specific case lend to the ticket being introduced and use these 2 exceptions as kind of like the reason why a judge should just let it in, even though it technically does not qualify. The third one you could try is a past recollection recorded. If the officer is still available and can be called to testify, the information in the record could then possibly be offered as a past recollection recorded. Congress is concerned about the defendant losing the right to cross-examine the police officer if their reports just replaced having the police officer come to court. So that wouldn't apply here since the officer would be present and the defendant could cross-examine him. So again, you're arguing kind of like that the reason behind why Congress made these rules, we don't have that problem here. And so judge, you should just let this in. A few courts or a few cases have applied this exception under similar facts, so it is possible. And then lastly, you could try the present sense impression hearsay exception. You might be able to lay the foundation here. Again, this is FRE 8031. Another police officer could testify that it's the routine practice to write down, license plate numbers while observing it or immediately afterwards. You could argue that the present sense impression exception has more safeguards than the records exception. And so again, trying to get around the introducing police reports and how Congress has made it pretty clear they don't want to do that. So you want to convince your judge that this is a different scenario and it should come in for these other reasons. That is all our casebook hypos for today. If you guys have questions about any of this, since we're not in person to ask questions back and forth, feel free to email me or we can talk about it the next time we meet in person. Have a good Halloween.